Welcome to section 19.1, part 3. This is the 195th session of the CISSP exam prep series. With the forensic techniques behind us, we now walk through running an investigation from start to finish. In this session, we'll cover the mechanics of an actual investigation. We'll answer several questions. How do you set up an investigation properly? What are the lawful ways to confiscate evidence? Do employees have privacy at work? When should you call in law enforcement? How do you conduct the inquiry and interview people? And how do you protect and report your findings? Why does this matter beyond the exam? Because a well-run investigation protects both the truth and everyone involved. Imagine a logistics company that suspects an employee is leaking shipping data to a rival. If your team acts without a clear mandate, you risk overstepping, tipping off the suspect, or violating their rights. A disciplined process keeps the inquiry fair, defensible, and effective. That discipline is what turns suspicion into a solid conclusion. How do you set up an investigation the right way? You start by assembling a team of competent analysts. That team should work under your existing incident response policy and receive a clear charter. The charter defines the scope of the inquiry, the authority and roles of the investigators, and the rules of engagement they must follow. Those rules spell out what actions the team may take at each phase, like when to call in law enforcement, collect evidence, or cut off system access. Think of it like handing a search party a map, a radius, and a clear list of what they're allowed to do. Without that framing, people improvise, and improvisation gets cases thrown out. What are the lawful ways to confiscate evidence? There are 5 you should know, and choosing wrong can ruin your case. First is voluntary surrender, which works best when the person is not the guilty party, since few suspects hand over what will incriminate them. Second is a subpoena, a court order compelling someone to produce evidence, though it also warns them in advance. Third is the plain view doctrine, where an officer may seize evidence sitting in plain sight during a lawful duty. Fourth is a search warrant, reserved for when you must act without tipping off the owner. And fifth is exigent circumstances, where an officer may search without a warrant because evidence would otherwise be destroyed or someone is in danger. Picture 5 different keys, each cut for a specific lock. Use the wrong one, and the door stays shut. Do employees have privacy at work? Usually far less than they expect. Outside government workplaces, most jurisdictions hold that employees have little expectation of privacy on company systems. Employees generally have the right to search the electronic systems they own and operate. You can strengthen this with a smart habit. Have new hires sign an agreement consenting to search and seizure as a term of employment. That consent makes confiscation faster and reduces lost evidence while you wait for permission. But the moment a search reaches into someone's person or personal belongings, the law gets complicated, so bring in an attorney. Think of it as the difference between opening a company-owned locker and searching someone's backpack. When should you call in law enforcement? This is a weighty decision that belongs to senior management. On one side, the experts bring real firepower. National agencies run dedicated cybercrime units with agents trained specifically for these cases, and they can coordinate with local police. On the other side, 2 forces push companies to hesitate. An investigation may become public and embarrass the organisation, and once law enforcement is involved, they must follow constitutional limits that would not bind a private inquiry. One of those limits is the warrant requirement, and it deserves a closer look. Picture calling in the fire department. They put out the blaze expertly, but they also file a very public report. Why do search warrants matter so much? Because they set the rules for when the government may search. A warrant must be built on probable cause, meaning real evidence that a crime occurred and that the search will reveal proof of it. That bar is much lower than what a conviction requires, and warrants are often granted on an investigator's sworn testimony alone. A warrant must also be specific, describing exactly what may be searched and seized. Miss even a small detail, and a court can invalidate the warrant and throw out everything it produced. Picture a permission slip that only covers one room of a building. Step outside those walls, and the evidence you gather does not count. How do you conduct the investigation itself? Carefully, whether or not law enforcement is involved. A few principles keep you safe. Except when capturing live memory. Never run your investigation on the compromised system itself. Take it offline, make a backup, and work from that backup. Never try to hack back and retaliate. or you may strike an innocent party and face charges yourself. And if you are ever unsure, call in expert help. Whether law enforcement or a private forensics firm, think of a crime scene photographer who documents everything but never rearranges the room. Your job is to preserve, not to disturb. How do you talk to people involved in a case? It depends on your intent, and the distinction is legally important. If you are simply gathering information to help your inquiry, that is an interview. If you suspect the person of a crime and plan to use their words in court, that is an interrogation. Before either one, plan your topics with a checklist so different subjects are questioned consistently, then adapt as the conversation reveals more. These are specialized skills that belong to trained investigators, because clumsy technique can wreck a future prosecution. Many laws also govern detaining people, so always consult an attorney first. Think of the difference between a friendly chat and a formal deposition. The stakes are worlds apart. How do you protect evidence and its integrity over time? 2 ways, and both matter. First, guard the integrity of evidence during collection, because altering it even slightly can get it thrown out. Second, protect the data before you ever collect it, since many incidents are discovered long after the fact. A key log that could unmask an attacker is useless if it was purged first. Attackers often try to wipe logs to cover their tracks, so send log records to a locked-down central server that does not allow changes. Digital signatures can prove logs were not altered after capture, and a simple archiving policy keeps evidence available no matter how old the incident. Picture a security camera that streams footage to an off-site vault the moment it records. How do you close out an investigation properly? With a final report and a standing relationship. Every investigation should end in a report documenting the goals, the procedures followed, the evidence collected, and the results. Formal documentation matters because you rarely know at the start whether a case will end up in court, and even an internal matter can become a legal dispute. Standard procedures and checklists keep your evidence admissible down the road, and everyone involved should be properly trained. Build a relationship with your legal team and law enforcement contacts before you need them, and name a single liaison to speak for your organisation. When trouble hits, that groundwork saves precious time. Picture exchanging numbers with your neighbours before the storm, not during it. So let's bring it together. A sound investigation starts with a team, a charter, and clear rules of engagement. You confiscate evidence through one of 5 lawful paths, remembering that workplace privacy is usually limited. Calling in law enforcement is a management decision with real trade-offs, and warrants must rest on probable cause and stay specific. You investigate from a backup, never hack back, and know when a conversation is an interview versus an interrogation. Finally, you protect evidence integrity, retain your logs, and document everything in a final report. Follow this arc, and your investigations will stand up to any scrutiny. The MCQs covering all the topics and concepts from this session are available on rucloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session.